So, welcome to the Electronics Watch Virtual Summit, Public Buyers and Workers Advancing Human Rights Together. My name is Björn Claeson. I'm Director of Electronics Watch, and we're going to start with just a few of the logistics here. If you need interpretation, then just click on the globe symbol to choose French, Spanish, or English as you need. If you need technical assistance, you can contact Electronics Watch in the chat. And this session is being recorded, as is tomorrow's session, and it will be available on the Electronics Watch website in a few days. So we have an exciting program with exceptional speakers today and over the next 3 days. Today, we will focus on the regulatory environment, human rights and environmental due diligence, trade measures, and reporting and transparency requirements, and how this environment can help advance workers' rights in public procurement supply chains especially. Tomorrow, as you see, the focus will be on battery supply chains and what effective human rights due diligence looks like in these new or partially new supply chains. And then finally, on Thursday, we will have a session called Stories of Challenge and Change, Monitoring Partners and Public Buyers in Conversation. This session is only open to affiliates, monitoring partners, and other advisors to Electronics Watch. So today, before we get to the panel discussion on our regulatory environment, we would like to show you and tell you about some of the exciting developments during the last year and offer you a glimpse of what lies ahead. In a moment, you will hear directly from some of the staff who are doing this exciting work. But first, we would like to show you just a very few highlights of Electronics Watch in action in 2023. And we're going to turn over now to the very short film. These were just a very few highlights. It was hard to choose. Now we're going to go directly to the staff panel who will tell you about their exciting work and what lies ahead. Each one of the staff that you will see on screen here will highlight one important theme of our work. And so we will hear first from Kate Sullivan, who is Affiliate Engagement Manager. Kate, so building the capacity of public buyers to use their leverage to promote and protect the rights of workers in their supply chain, this is at the core of our work. And then over the past year, we have really stepped up support for affiliated public buyers. And affiliates have created increasingly effective demand for supply chain transparency and also for effective human rights due diligence in general. Can you tell us, what do you see as the most exciting developments over the last year?
Thanks, Björn. I'm happy to do that. But first, I think, because I know there are others on the call who maybe are less familiar with who our member organizations are. So I thought I'd take a minute just to talk about them quickly. Our affiliates are over 1,500 public authorities who are quite diverse in terms of their size, their spend, their organizational structure, and location. They include central purchasing bodies at the national level, regional authorities, municipalities, universities, and purchasing consortia. Our affiliates come from 12 different countries, mostly in Europe, but also in Australia and one international organization, the OSCE, which is located in Vienna. So these very diverse organizations, one of the challenges that we have is how do we build their capacity both at the individual level and at the collective level? And I think those are the two categories of developments that I'll share with you today. In that first category, we've started to deliver more consistent and more standardized reports to our affiliates, and I want to flag two examples of those from the last year. The first is the introduction of an initial risk assessment report for organizations who submit their product information to us for the first time. What this report does is it helps them to better understand the risks in their supply chain, whether that's based on the geography or on the specific products they're purchasing in different tiers. But also it motivates them to carry out supply chain mapping and to advance their responsible procurement work. So that's the aim of this report. The second example is the introduction of quarterly monitoring status reports for affiliates that have shared their product and supply chain information with us. These provide updates on monitoring findings and remediation activities, as well as offering guidance on how our affiliates can engage their contractors. In the second category, which is about efforts that we've made to facilitate collaboration between affiliates, there are a number of examples we could highlight, but perhaps the most interesting is the additional energy that we've put into cultivating working groups. So some of the working groups are issue-based. It could be around a particular risk, while others are focused on improving the transparency and accountability of common suppliers. The purpose of the working groups is to offer a forum where affiliates can work together on common problems and learn from one another's experiences, but also to create a channel for them to coordinate supplier engagement to drive positive change for workers. So this is about increasing their collective leverage and the effectiveness thereof. There's also a lot of exciting things that are on the horizon, and we won't go into all of them now for the sake of time, but I do want to highlight one in particular, which is a maturity matrix and self-assessment tool that will help affiliates to evaluate how they can invest their time to have the greatest impact, understanding that public authorities do a million different things and have a lot of time and resource constraints, and also how best to make use of their electronic swatch affiliation. So this tool indicates what socially responsible public procurement and due diligence look like at different stages, drawing on the steps outlined by the OECD, and how each organization can advance from one maturity level to the next. I should say that this tool isn't something that we've just come up with out of thin air. We've actually adapted it from a tool that was developed by Griffith University on maturity related to modern slavery. So thank you to them for that beautiful template that we're now adapting. And the aim is to have that launched at the latest in the beginning of next year.
Great, thank you, Kate. This is really interesting work. But we're going to move ahead in the interest of time. We're going to have to keep it pretty short for every speaker. We have 6 people. We have until 10:30, and the other panel is going to start right then. So we're going to move next to Rocio Paniagua, who is manager of our low emission vehicles program. And so over the last year, we have started working with 10 pioneering public buyers to learn how to use public procurement leverage to promote the rights of workers in these new electric and low emission vehicle supply chains. And this, I think, is critical work to ensure that climate solutions do not come at the expense of workers, but with that we have a just transition toward a new energy future. The work, I should say, has been supported by the European Partnership for Responsible Minerals, the City of Barcelona, and the program participants themselves. So, Rocio, can you tell us what we have learned about public procurement leverage in this sector?
Thanks very much, Björn. First of all, I'd like to explain a little bit of what the program does. So what we are trying to do is to support the participants to meet human rights due diligence obligation on the procurement of low emission vehicles. And we want to do it in different ways. We do it through building the capacity of public buyers, or the participants in this case, to implement social responsible procurement practices. We also establish supply chain transparency. We also help them and provide them with worker-driven monitoring information on their supply chain. And we also facilitate remedy for labor rights violations in their supply chain. So at the moment, as you were saying, Björn, we have 10 program participants, among which we have major public transport organizations. And it's important to note that supply chains are long, large, complex, transnational, but our focus here is high-risk strategic central components. We are looking into batteries, semiconductors, and minerals. So let me focus in one of the areas of work that we have been doing in the past year, and which we think is critical to strengthen human rights due diligence. This is supplier engagement. The main takeaways of the supplier engagement we have carried out this last year are the following. First of all, the vehicle sector is far behind other sectors when it comes to establishing supply chain transparency and human rights due diligence. It's behind ICT, garment, but there is also important aspect to highlight, which is that public transport companies have leverage over manufacturers. They are hearing what they have to say in terms of social value requirements. And for an engagement to be successful, it is very important that it is proactive. Public buyers need to be proactive. It's not a one-off thing, it's a continuous process. Also, just to finalize, I want to say that collective leverage and building trust are also being critical. And we trust that in the next, very soon, we will start having we will start to receive disclosure from vehicles manufacturers, and this will allow us to address cases and systemic issues in the supply chains of the vehicles that our participants purchase.
Thank you very much, Rocio, for that concise summary. Being proactive, building trust, creating collective leverage, some very important themes. So we'll move right ahead to Petra Kreczmarova, who is program assistant. And we're going to stay on this theme of supply chain transparency that Rocio highlighted in terms of getting factory disclosures, excuse me, from companies. Apologize. This is, of course, a foundation of any effective human rights due diligence, which is why our affiliates have been pushing very hard to link the product models that they're buying to the factories where those products are being assembled and where the key components are being made. So Petra, as you maintain our supply chain database, just looking at that database, what is the state of our supply chain transparency today?
So the level of transparency is based on our database definitely increasing. But first of all, I need to say that the supply chain database is confidential and available only to Electronics Watch. Database contains information about the products our affiliates procure and the addresses of factories where the products were manufactured and assembled. And how do we use the data? We plan the monitoring activities with our monitoring partners to drive change in the supply chains of our affiliates. We then report back to our affiliates on the risks, monitoring, and remediation results via, for example, the monitoring status reports, which Kate mentioned, that are all guided by being able to link an affiliate to a specific factory. One of the things we can see is that public buyers are increasingly becoming aware that human rights due diligence needs to be based on evidence as the amount of data in our database rises. And it all starts with knowing where their factories are. Based on the disclosure trends, we can see that brands are increasingly being transparent about their supply chains to public buyers. To give you an example, a year ago, we had 20 brands disclosing factories, whereas today it's 43, which is more than double. Some brands are, however, still lagging in providing disclosures, which is a challenge we work on with our affiliates. To give you a deeper insight into the database, besides final assembly factories, we are increasingly seeing component suppliers being disclosed related to specific product models. Our database also covers 27 countries globally in comparison to the last year when the number of countries was 17. We also have more than 200 factories in our database, whereas last year it was less than 100. And some of the plans we have for the future is to make the process of factory disclosures easier for both our affiliates and the suppliers. With more than 1,500 affiliates, we also need to think about how to handle high volumes of data. We also want to be able to customize the reporting for each of the affiliates and present the data in a more visualized data space. So we have shown that supply chain transparency is possible. And if companies can disclose factories to public buyers, they can also be more transparent to the public, which is something we hope to see more in the future, as companies might be required to do so by several national and international regulations.
Thank you very much, Petra. And it is encouraging to see the progress here, which I think is a testament to the increasing influence and leverage of public buyers in these supply chains. So we're going to move right ahead. I'd like to welcome Omana George, who works very closely with our monitoring partners, especially in Asia. So Omana, when we have supply chain transparency, it means that we can connect workers to affiliates, to their supply chains. And that connection is the foundation for affiliate leverage over factories and for an effective external grievance mechanism. We have been working in collaboration with the GIZ's Initiative for Global Solidarity to expand access to effective external grievance mechanisms for workers in several countries. So can you describe how we set up these mechanisms in different countries and how they look in different countries?
Thank you, Björn. As Petra shared, monitoring activities of Electronics Watch are planned based on factory disclosures, which we get from our affiliates of where procured products are manufactured and assembled. Now I'm going to illustrate this with a few examples. Workers basically access our monitoring partners during outreach activities through existing networks, through trade unions, other known contacts, which basically makes workers comfortable. And this forms an open communication channel between the monitoring partners and the workers. Then they begin informal discussions to build comfort and trust for dialogue, and then gather information from the workers about the conditions of their workplace. This can happen through guided discussions like focus group discussion, open-ended interviews, and surveys. Now I'll go into an example in one country. In Malaysia, our monitoring partner engages with workers in a training or a workshop where initially what they do is they share with the worker about their rights at work. What are the laws which protect them? This serves as an entry point for the workers to open up and start sharing about their workplace, the grievances they are facing, and the hazards they might be encountering at work, etc. In the case of Vietnam, our monitoring partner has developed the WeCheck app, which can be the first point of contact when a worker downloads this app. And through this interface, share some information about themselves, their workplace, and some of the issues they want to address. Then our monitoring partner can communicate with the workers and further engage with them directly after making first contact through the app. Then they can gather data and follow up with Electronics Watch. we quality check data received to ensure that the data we get is relevant and credible. Now, trade unions also in countries of production reach out to Electronics Watch regularly on cases where workers are being abused, cases of union busting, and in situations of forced labor. And they ask Electronics Watch to jointly monitor the workplace and seek remedy for the workers. Trade unions see that public buyers affiliating with Electronics Watch can use their leverage to address worker grievances in workplaces where they are procuring from. They see this as an effective way of seeking remedy for workers. Looking ahead, we affirm that freedom of association and the right of collective bargaining is the core of workers' rights. We see that building capacity and the knowledge base for our monitoring partners and trade unions whom we work with on co-labor standards and monitoring the same for grievances of workers and remedy is the way forward for us. Thank you.
Thank you very much, Omana, and for giving this work a sense of reality and groundedness in workers' experience. I apologize. So we turn to Aikut Kazanchi, who leads our work to strengthen our monitoring capacity and is meeting lots of monitoring partners on a daily basis in order to do that. And so Aikut, as Petra already mentioned, one critical ingredient of any human rights due diligence scheme is evidence. How do we really know that there are or are not risks in supply chains? How do we know that workers have or have not suffered harm? So if we get this wrong, then due diligence can become no more than a tick box exercise and potentially causing more harm than good because we hide the abuses in the supply chains. If we get it right, if we have good evidence and that we're confident in, then we can really have an impact. So can you explain what we are doing to make sure affiliates and other stakeholders can rely on the evidence that we produce?
Thank you, Björn. I think I can, because this is one of those things that's relatively easy to explain, hard to do. Our evidence approach is just the opposite of common sense approach. Because we all have common sense, we like to rely on common sense. But we think we need to depart from common sense when it comes to evidence-based monitoring. That is our real objectivity pillar in worker-driven monitoring. Of course, we value every bit of information from workers, the unions, activists, partner organizations, but we use a critical approach to ensure we don't miss any details or proofs when we want to support their statements and claims. Here is an example from a recent case. A trade union addressed an issue to us with migrant workers at an electronic factory. The employer required these workers to pay a certain amount of fee to go on a leave, to go on a vacation, only to be paid back when they return to work as a guarantee to get to work. So is this a clear sign of forced labor? Most probably, but not clearly in our case. We cannot stop there. So we asked questions. First things to be checked was, is this a current practice or is it just something from the past history? How many workers have been affected? From which nationalities specifically? Any documented proof we can use? How much is the fee? Is it legal per local law? Any worker who feels trapped legally, literally in this practice, unable to visit her family in the home country, and so on. So this is how we train all our monitoring partners to ask these questions for an evidence-based monitoring in about half of the 27 countries that Petra was mentioning. This is what we are focusing and they are focusing, and this is how we quality check all our monitoring reports landing on us. The fact that we are focusing on evidence-based monitoring differs from mainstream checking, mainstream auditing in the industry. We are working on this directly with the workers and their representatives. This is the model worker-driven monitoring. And to that end, the good news is we now have a formal plan to move towards a resource and training center for evidence-based worker-driven monitoring to create a real impact on the monitoring world. So, thank you.
Thank you, Aikut. A very exciting plan, and thank you for giving us a glimpse of how we think about evidence. So finally, I would like to welcome Cindy Berman, who is our Director of Impact and Innovation. And so we have transparency, we have workers' grievances, we're getting good evidence. The next step, of course, is remedy for workers who have been harmed. But remedy is legitimately, I think, known as a weak link in human rights due diligence. There's little common ground among stakeholders on what it is or should be or how we get there. But we have made some exciting progress in this area. So, Cindy, if you can explain what we have achieved so far and how you think together we can make remedy real for more workers in global supply chains.
Thank you, Björn, and it's wonderful to connect today. The concept of remedy has been largely neglected or misunderstood for many years. Remedy is about righting the wrongs of workers and communities when they are harmed by businesses or the state. Yet for many years, this concept has been used by companies to mean corrective actions, which are often tick box, top-down exercises that risk assure businesses. Having said that, in the last 5 years, we've seen some remedy cases involving repayment of recruitment fees to migrant workers who are essentially debt bonded due to the crippling fees they paid to secure their jobs. We've also seen some businesses setting up helplines and apps run by third parties to enable workers to raise complaints. They're called worker voice tools, but they rarely include workers in the design, and often workers don't trust them as they worry that if they raise a complaint, they will lose their jobs or be punished. If workers report anonymously, it's very difficult to follow up on specific cases. So Electronics Watch has a completely different approach. We want to see remedy resulting in change, enabling workers not only to receive what is owed to them, but also to have a greater voice and choice at work. We start from the perspective of workers. We ask them about their working conditions and treatment, as you heard from Omana and other colleagues. We learn about their grievances, and when violations are found, we ask them what kind of remedy they want and need, and we involve workers every step of the way. We've developed a set of worker-driven principles that put workers at the center of remedy processes. And in doing so, we've consulted public buyers, trade unions, NGOs, and academic partners, many of whom are on this call today. And we thank you for your input. Now we're inviting all organizations, including businesses, to use these principles. We'll be producing operational guidance for public buyers so that they can use these principles in a practical way. And we'll support labor rights organizations in their efforts to make these principles a reality for workers. We want to engage with companies to help them understand that treating workers with dignity and respect is ultimately the most sustainable way to run their businesses. Solving problems as and when they arise through social dialogue between workers and employers is effective. Establishing credible and trusted operational grievance mechanisms in all workplaces will go a long way to prevent harm to workers and avoid grievances from escalating into strikes, high turnover, and losses in productivity. We want to see the narrative changing in relation to remedy, putting the needs of harmed workers at the center where they belong.
Thank you so much, Cindy. And I think that this work on remedy really is a critical work to transform global supply chains, because you can't have remedy without a meaningful voice for workers. So if you get remedy, you're also going to shift the power imbalances a bit. So thank you very much to everybody. Very exciting stories, I think. We're moving on now to our feature session today. So I invite all of you to go on camera. And the feature session is Advancing Workers' Rights in Public buyer supply chain, the potential of the new regulatory environment. It's my great pleasure to introduce the moderator, Olga Martin Ortega. Olga, where are you? I can't see you. There you are. So Olga is perhaps not her primary title, but she is Senior Advisor for Remediation in Global Supply Chains with Electronics Watch. And she was a member of the Board of Trustees of Electronics Watch from 2014 to 2022. Has been involved from the start. But of course, you wear so many other hats. Just some examples. Olga is Professor of International Law at the School of Law, University of Greenwich, where she leads the Business, Human Rights, and the Environment Research Group. You are also the head of Natural Resources and Just Transition at the Business and Human Rights Resource Center, has been on the board of directors of the London University's Purchasing Consortium since 2015, and on the board of Corporate Justice Coalition in the UK since 2018. And I think, Olga, you're widely recognized as a leading voice and expert on business and human rights, public procurement and human rights in global supply chains and due diligence, among others. So with that, I'd like to turn it over to you. Look forward to this panel.
Thank you so much, Björn. Thank you for that really warm introduction. It's my absolute pleasure to be here and to be moderating the first panel of the summit. And as Björn said, I've been involved with Electronics Watch from the beginning, and I am absolutely amazed, but not surprised of this fantastic progress that we've heard and that we've heard from all the staff just now. So today we have a very exciting panel. We have a panel with very important voices where we're going to be discussing how we are advancing workers' rights in public buyer supply chain, in which context, in the context of the new regulatory environment, and what's the potential for it. And all these practices that we've been hearing in the from the Electronics Watch staff just now are happening in this context of the regulatory environment, which is a very exciting moment, I think. This context enables and to some extent mandates what public buyers are doing and what their suppliers are doing, and this mandating of obligations is increasing. And we've waited for a decade to get the standard of human rights due diligence to be started to be hardening from the soft law of the UN Guiding Principles to new national laws and EU level laws, and increasingly both mandating human rights due diligence, but also transparency in supply chain and disclosure obligations, especially with regards to modern slavery. So, but in the meanwhile, while the regulators are busy doing this, public buyers have not stopped their practices, as we've seen, and they have been increasing their expectations and standards in their own supply chain and in due diligence. So how do these two, the practice of public buyers and the regulatory environment, intersect, and what is the potential is what we're going to be discussing with, as I said, a fantastic panel. Let me just say a little bit about how the panel is going to work. We've paired the speakers into mini conversations that we're going to have on their specific focus. And then we will bring this all together and open the floor for questions and answers as well. So let me start with our first speaker, who's going to tell us about this regulatory environment and provide the scene for us. And it's someone that doesn't really need introduction because he has been is the leading voice, one of the world leading voices on business and human rights. Is Professor Robert McCorquodle, who's currently a member of the UN Working Group on Business and Human Rights. But Robert has been advancing business and human rights for decades now. He's an emeritus professor of international law and human rights at the University of Nottingham, and also a barrister and mediator at Brick Court Chambers in London. So Robert, I will now like to open this panel by listening from you about where are we, what's happening, how are roles shifting, and how are international law developing in this a fantastic and exciting time.
Thank you very much, Olga. I do appreciate that kind introduction. I thought it might help just to begin with explaining the UN Working Group on Business and Human Rights, because I suspect not that many of you know our existence at all. So when the UN Guiding Principles, about which I'll speak in a moment, were adopted in 2011, there was created a working group on business and human rights to kind of carry this forward and try and implement it. We are 5 members who are meant to be experts. We cover from different regions in the world. I represent the extraordinary region called WEOG, Western Europe and Other Group. And obviously it includes Western Europe. It also includes others you might have heard of, such as the United States and Canada, Australia, thankfully for me, and New Zealand, and Israel and Turkey. So not a very coherent region. Nevertheless, the 5 of us have a range of different responsibilities. We produce reports. We've just produced, for example, a report on the extractive sector and what just transition means for that. We're about to produce a report on investors, ESG and human rights. We also have many, many conferences and things we organize. We do country visits. 2 of my colleagues have just come back from Japan. We're going to Tunisia in a couple of months. And we also do communication. So we do take complaints from anywhere in the world and consider ways forward, which means we will publicly raise issues with companies and with governments about issues concerning business and human rights. So that's kind of what we do. The other thing, and in a way, Olga's already disclosed, I've been in this field probably too long, but 30 years ago when I first began, when I spoke to businesses about these issues, they would say, nothing to do with us. Human rights are a matter for governments, not a matter for business. And when I spoke to governments, they'd say, similarly, it's all about us. We determine, we've got sovereignty, we've got power. Now I sit in UN meetings where all governments agree, there's no dispute that businesses have responsibilities. And many of the businesses that Electronics Watch deal with, they will have somewhere on their website some kind of reference to human rights policy, or perhaps even refer to the UN Guiding Principles on Business and Human Rights. So that's the huge change which has begun already. Now, of course, you know what the UN Guiding Principles are, as I say, began back in 2011. They also, a key element of this is they introduced the concept of human rights due diligence, which has to be about businesses looking at what the human rights impacts are on the rights holders. Now, that's not how businesses normally look. They normally look at the risk to them, not the risk to others. And so that is a significant change. What I'm hoping to do is very, very briefly give an idea of where things have moved since 2011. The starting point is that across international regulation, there's been quite an impact. So, for example, the OECD guidelines, and the OECD guidelines cover all governments and businesses which are in the sort of developed countries. So that's about 40 of them. And so the OECD guidelines on responsible business conduct includes human rights requirements. The International Labour Organization Declaration on Multinational Enterprises includes human rights requirements. And what has also happened is these have begun being referred to directly and indirectly in national and regional legislation and in decisions by courts and other disputes mechanisms. I'm going to give you some examples of how that has begun to infuse the whole kind of regulatory framework for which businesses are involved. For example, in the past few years, there's been broad-based mandatory human rights due diligence national legislation. That means requirement on companies to undertake human rights due diligence, to identify, to track, to communicate, to find out what's happening in relation to their human rights impacts. Some of those are in France, the Duty of Vigilance Act of 2017, in Germany, the Corporate Due Diligence in Supply Chains Act of 2021, in the Netherlands, the Child Labour Due Diligence Act of 2019, and in Norway, the Transparency Act in 2021. But also outside that context, in Sierra Leone, the Customary Land Rights Act of 2022. There have been some, what I would say, more limited business and human rights national legislation, such as the Modern Slavery Acts passed in Australia, Canada, and the UK, and I know James is going to talk about those, and the Uyghur Forced Labour Prevention Act in the USA. At the regional level, and I think most importantly for many of the businesses here in this seminar, the EU has passed a number of pieces of legislation which directly impact on business activities which affect human rights, including with respect to the environment and climate change. For example, just in the past few years, the Corporate Sustainability Reporting Directive, about to come into force in a few months, the Sustainable Finance Directive, the Conflict Minerals Directive, and the Green Taxonomy. And in addition, and very likely soon, the Corporate Sustainability Due Diligence Directive. It's just in the final discussion, so we're not sure of the exact provisions, but it's clear it will include mandatory human rights due diligence for the largest business. It will include environmental issues. It's possibly going to include climate change reporting. It also carries with it civil remedies for non-compliance and supervisory mechanisms. And also importantly, it applies, like much of the EU legislation in this area, not just to businesses domiciled in the EU, but also to businesses domiciled elsewhere and operating in the EU. So that's potentially global consequences. In the courts, the position has also moved considerably. So, for example, parent companies based in the global north have been held to have a duty of care towards those rights holders affected by the actions of a subsidiary domiciled in the global south. That's been held, for example, by the Supreme Court of the UK and by Dutch courts. And that's even in situations where that company is operating as a joint venture, as was decided by the Canadian Supreme Court. And more recently, a major oil company has been required to change its greenhouse gas emission based on its responsibilities under the UN Guiding Principles and climate change requirements in a case called Milieu de Francy and Shell in the Dutch courts. But other dispute mechanisms have held financial institutions to have responsibilities for their investments, which enable companies to act in ways that have adverse human rights impacts. For example, ANZ Bank in Australia, under the National Contact Point, was considered to not have undertaken their human rights due diligence, with a direct consequence on its investment in a sugar plantation in Cambodia. There's also been requirements on companies and on investors about climate change. For example, the working group itself has done a communication on Saudi Aramco, the world's biggest oil and gas company, in which it's raised concerns about its impact, including to the 11 largest investors in Aramco, because without their investment, Aramco wouldn't be able to do what it's doing. And of course, investment tribunals have noted that businesses have responsibilities with regard to human rights. Let me just finish by saying, I would also say the increased activity by civil society organizations such as Electronics Watch, who have begun to focus on business and human rights issues, are vital for ensuring that businesses are aware of the reputational, operational, financial, and legal risks of not acting responsibly. I just want to make sort of one other point, which is most of these developments have been somewhat piecemeal and generally global north-centric. Nevertheless, these developments show a clear direction of travel and with global consequences for all businesses. Thank you.
Thank you very much, Robert. It's a really good overview of what's happening, and the last decade since the UN Guiding Principle, and how really this it's now at the forefront of practices for states and businesses, and the way the public sector has also picked up on this is very important, and we've seen the practice through what Electronics Watch is doing. So I'm now would like to bring in Jonathan Jansen as well to have this conversation with yourself. Jonathan is coordination of the Ghent Fair Trade, which is a collaboration between the City of Ghent and Oxfam Ghent. And I would like to ask you both this question of what changes we can anticipate from the EU directive, the CSDDD, the Corporate Sustainability Due Diligence Directive. And there's been a lot of talk, or at least with some of us have tried very hard to push the EU to include public buyers in the directive to some extent, to either have themselves human rights due diligence obligations, so to be able to use the lack of due diligence as something that public buyers can call upon their own suppliers. So Jonathan, as well, drawing a little bit on your experience in Ghent, tell us what changes do you anticipate that the CSDDD could bring, or how do you think it may impact as well on what public buyers have been doing?
Thank you, Olga, and hello, everyone. I have to say that I think that so maybe I should introduce a bit the city of Ghent. So we consider ourselves, and we're considered a front runner when it comes to sustainable procurement. This is because we are implementing human rights clauses in all tenders. We are elaborating. We have an elaborative fair trade policy, and we're doing some work specifically on textiles and electronics together with Electronics Watch. So this new legislation is very big scale. It's so in general, we are really focusing on specific products since there is no anti-slavery law like we have in the neighboring countries. What I see today, and this is so what we have been doing in the past is creating an overview of what we are buying and linking these product categories to human rights risks. Today, the buyers of the city of Ghent are collaborating very closely with so-called thematic groups in the city, like the team that I work for is the International Solidarity Team, to for each tender make specific criteria and specific scoring systems to try and avoid human rights violations within the production process. And what I notice is that it's a very labor-intensive task for a small local authority to do. We have the political support and we have good people in the city that want to support this process, but this is not feasible for every city or every village to do, and this has a lot of reasons which are all actually linked to the CSDDD. So, for example, I think one of the implications could be that one of the challenges that we encounter now, the lack of information, the lack of transparency on supplier side, could be less. Could be less of a problem, since when it's put into legislation and when it's enforced from a higher level than just the buyer. I also think that at this stage, human rights criteria are really non-binding from a public buyer side. It's not really an obligation for us to be aware of it, or to have a strong buying policy around it, and which makes our efforts that are at this stage have been built since the 90s, which makes them very sensitive to, for example, elections. We could have one election that turns out not in the favor of what we have been doing in the past 30 years and erase almost all knowledge and experience within the organization. And I think, I hope anyway, this CSDDD draws a new lowest bar, which makes it less of a sensitive topic, so to say. Lastly, I was thinking about monitoring, which is a very big challenge for us. Monitoring of what we expect suppliers to do is very challenging. We are relying on partnerships with Oxfam or Electronics Watch, but also on labels and reporting schemes. But all of these have their limitations and also require a very labor-intensive follow-up from city employees. So maybe the CSDDD can provide a solution for this because it's lifting the obligation to work transparent to a higher level. So maybe this is some ways that it can change.
Maybe I can add a couple of additional things.
Yes, please.
Jonathan has said. The starting point is, of course, UN Guiding Principles apply to the public sector as well as the private sector. So it applies to state-owned enterprises. It applies, say, for example, to a public body pension fund. So it covers a range of different entities. And it also would, in our discussions at country visits, we would expect governments to and the broader public sector to be leaders in this field and not behind. However, the sad thing is across most of that regulation I mentioned, other than the legislation in Australia, none of them apply directly to the public sector. And that is a concern because it means that that sector is not necessarily engaged with directly by legislation. However, I would say two things. The first thing is legislation often operates as a kind of often what's called a stick, but public procurement is a carrot. If public procurement is operating really, really well and really effectively, it can be an incentive for a business which wants to tender for this to have some human rights due diligence, if that's a requirement of the public procurement. So it can be a very, very effective way of moving the private sector ahead. It also can be a way internally in the public sector for them to be able to realize they also need to look internally and do their own human rights due diligence, because it can be a significant impact of public activity on human rights. And one sees that when dams are built, for example, and people are just moved off their long-held areas which they've lived just for the sake of a public investment. So there are significant potential impacts. As far as I know, and Olga, I'm sure you know better than I do at the moment, there is not likely to be that happening in the CSDDD, but we still are waiting for that to be clarified.
Yes, and I think thank you very much, Jonathan and Robert, for this, because I think this demonstrates what Jonathan is saying and how, Robert, you are actually probably right. The public procurement is not likely to feature, not even as a general kind of carrot of accessing public support to suppliers, but the role of the regulation is really important. Is that because, as Jonathan has exemplified, the public buyers are small teams, and they are people really trying very hard to do two functions: those that are committed to social, to advancing their own social commitments, to actually the function of buying effectively, and the function of using the tools that they have to advance this social agenda. So how what of a missed opportunity could this be if we don't have this regulatory framework that actually assures Jonathan that he can continue with this, and he's going to be listened, and the resources are going to be put into that. And so what are the consequences of not having this framework, or the missed opportunities, and what can we do about it, if anything?
My hope is part of this process of the creation of the structure under the CSDDD, the Corporate Standard Due Diligence Directive, will include effective supervisory mechanisms. And those that's its intent anyway. And those supervisory mechanisms can be operated and guidance given to, for example, public procurement. That would be consistent in SAC. For example, there's a variety of kinds of supervisory mechanisms in the Netherlands, and some of those seem to have an impact in their guidance on the public sector. So that's one way, if you like, sort of as a clarification of the regulation, which could help in the guidance which is provided. And also just more generally, the reminder that the primary bodies who should be taking this forward are, of course, the states, the governments. At the same time, of course, slightly parallel to this, there is a business and human rights treaty process, which could also have pressure put on it so that public procurement becomes a greater part of that understanding on the expectation of what governments should be doing.
Thank you. Yes, and therefore, Jonathan, do you you've expressed very well how this would help to have like a mandate from ahead and from the top. But do you see in your practice that our public buyers maybe preparing for potential obligations, or is this any kind of incentive to continue this work, or at least reassuring public buyers that, as you said, the institutional memory is not just going to disappear and the practice will end up not continuing?
To be fair, there's a lot of talk about this legislation coming for a long time already, and I don't see a lot of preparing going on actually. Now, I think if I look at other cities in Belgium, most are looking to the regions to prepare and to link their public procurement policy to, for example, for the Flemish region. I know you have a speaker of the Flemish region tomorrow, so maybe he can give some insights in this, because yeah, it's a very it's very technical, and it's especially for smaller authorities, it's not that easy to do this on their own. So maybe the preparing is in clustering or looking at higher authorities to look for help. But at this stage, for me anyway, I don't see a big change in how we are working. But yeah, for us, the biggest challenge in the past years was identifying where the risks lie and creating a way of working, creating a process in which we link experts to buyers, and this process has been going on from in Ghent anyway, from long before the legislation was proposed. So we are continuing in that path for the moment.
Can I just add one point? It's good to hear how Jonathan's process in Ghent is doing, because that's actually quite crucial. The engagement and consultation with rights holders, really important, so that those on the ground affected by these activities are consulted. Now, that is often already a requirement in many states, but often not taken forward in the public procurement area. But that's part of human rights due diligence, is to undertake consultations with rights holders to see what impact is occurring on them. So if that could be just sort of enhanced in that process, including right now, because as I say, many states already have, particularly across the EU, already have these requirements of consultations, it would enable a much softer development and progression, which is still within the broad framework of state activity, but would enhance the beginning of an effective human rights due diligence and require then the company seeking to obtain the particular tender to begin to actually do that action themselves.
Yeah, great. Thank you very much. This connecting with what Robert you just said, that even if the CSDDD will not apply directly to public buyers, the principles that is establishing the framework of how we should be supplying and relating, having a relationship with our suppliers and all the stakeholders in the supply chain that are affected by our procurement decisions, by our buying decisions, are valid, which is the principles of human rights due diligence and remedy for harm. And you both highlight therefore the value of collaboration, both collaboration with other public institutions, public bodies, public buyers, and external stakeholders. And again, pick up with the work that Electronics Watch is doing to support this. And there's something pending for all of us, academics, civil society, which is to continue to push for clearer, stronger regulatory framework for public procurement and human rights. It's obvious. So thank you very much to Robert and Jonathan. We're now going to move the conversation to another very important and interesting regulatory framework, which we, of course, can learn a lot, both in its setting, but also in its practice. And we have fantastic two speakers for this panel. We're really grateful as well that you could join us. We have Dr. James Cockayne, which, as you know, is the New South Wales inaugural independent anti-slavery commissioner, first one. But prior to his appointment, Dr. Cockayne was an international lawyer and a very well-known professor of global politics and, of course, an anti-slavery leader. With James, we have Esti Marco, who's director of the Modern Slavery Unit at the University of Sydney in Australia, where she's leading the university's strategic response to the Modern Slavery Act and enabling academic excellence in business and human rights. So, Esti, I'd like to start with you to look more at a federal level, because we know that both Australian and the Australian Federal Act and the New South Wales Modern Slavery Act go further than previous human rights disclosure legislation, and they include public buyers in this scope. So if you can tell us a little bit about what are the main differences and why is this important, but also focusing on the federal level, what is the as well what's happening in at this particular moment with the extensive review that the government has committed to, and what does that mean for public buyers? Thank you, Esti.
Thanks so much, Olga, and so wonderful to be with you. And I've learned so much in the last 15 minutes that I've been taking notes. I should actually just start by disclosing that prior to joining the University of Sydney, I spent most of my career working in government at the federal and state level. And so from my perspective, the fact that the Modern Slavery Act here in Australia, the Federal Act applies to public buyers in the public sector really is no surprise. And perhaps it's an Australian cultural element where if it didn't apply to government, but it applied to business, there would be riots in the street, because there is this expectation that government will lead by example, especially where it's requiring business to make significant investments in understanding its risks and its impact on people. But I really liked what you had to say, Robert, because I do think, and from a more academic perspective, and so being on the other side now within the university sector and working really closely with government, and we engage with government very closely on its legislative reform and policy settings. it is true. Government procurement is an extremely important carrot. And let me just give you a bit of colour and context to that within the Australian context. In 2021 to 2022 financial year, the government spent $80 billion on procurement of goods and services. That is across 92,000 contracts. And it included 98 government agencies within that. So if you think about, and within that 80 billion, about 6 billion of that was just in ICT components, equipment, and software. So if you think about $80 billion and a market wanting to get a small piece of that pie, then of course you're going to want to comply with the tender requirements of a public buyer, such as a government entity like Defence or Home Affairs or a really large department. So I think it's really, and perhaps this is an Australian cultural thing again, but I remember my days in government. Especially at a public policy level, there is this understanding that the role of government really is to provide market confidence through regulation and regulatory reform. But the other way it does that is by practicing what it preaches and putting those requirements in the marketplace through tenders and through procurement requirements. And government procurement is big business. So when the government and public buyers establish a standard, it really does actually lead to a race to the top, because there is a market incentive to comply and to meet those obligations. So, I hope that the opportunity is also seized on in other jurisdictions, and they see that the role of government really is to lead by example and to be a leader, because ultimately, what we've seen, from our perspective, as a university, we also provide services to the government, and we have been asked, in order for that contract to continue, we now need to meet those requirements. So suddenly we have faculties and schools that didn't want anything to do with my team coming to us saying, please help us meet these mandatory due diligence obligations, because we want to continue this contractual relationship we have with this public buyer. So it really does cascade down into how the market responds and how committed businesses are, because ultimately, and I can't remember who said this earlier on, but in the discussion, but ultimately, this really, business needs to understand that this is a strategic opportunity for them and not just a compliance burden. And I think that's one way for government to demonstrate that. What's really interesting to note is that, to your question, Olga, and I know James will have much more to say about this, certainly with what's happening in New South Wales and what the government's looking to do in reflecting that federal commissioner role. But the federal act in Australia is not a mandatory due diligence act. It's a mandatory disclosure legislation. So companies and public buyers are really just expected to disclose what steps they've taken. However, it is important to note that to do so, there is implied due diligence steps that must be demonstrated. And the Modern Slavery Act was recently reviewed. There was a statutory review undertaken by Professor John McMillan, and as part of that review, a number of recommendations, significant recommendations, were tabled in Parliament here in Australia. And one of those is that mandatory due diligence be adopted and embedded into the Act, so it moves beyond just disclosure, and that penalties be imposed, that the threshold for reporting entities be lowered from 100 million to 50 million, and that a federal commissioner be appointed to support public buyers, but also other reporting entities with meeting that new due diligence standard. So I think where Australia is moving, at least from what we're seeing, and we're watching this really closely for various reasons, but is really understanding that if we want to really establish a new standard of doing business, then that really needs to be backed by very strong, clear legislation and by really clear, strong guidance. And the best way to demonstrate strong guidance is through practice. And government is really well placed, and public buyers are extremely well placed to do that. And look, I can tell you that, when we first put our first modern slavery statement together, everybody went and had a look at the government's, the Commonwealth government's public statement to see what standard they were establishing for everybody else. And that's just one small example where public buyers do have that leadership role, and there's a really amazing opportunity for them to do really good and meaningful work.
Fantastic. Thank you, Esti. It's a very good reflections and overview of how this leadership role is happening and can happen. And linking with that, obviously, we have to bring James in, because the New South Wales law had this very advanced provisions, but also since he took office, he's made a very clear lots of clear noises of how important the role of public procurement is going to be for the office, and a fantastic work in this constructing of guidance and both carrots and sticks. So, James, I would like to bring you in. Tell us about your office, but especially the amazing work that you're doing with the public sector and the Modern Slavery Act in New South Wales.
Thanks, Olga. I'll try and make lots of clear noises tonight as well from over here. So I want to begin by acknowledging that I'm on the traditional country of the Bundjalung people here in the northern part of New South Wales, and that First Nations peoples in Australia are survivors of modern slavery as it's defined these days under Australian law. We live in a federation. It's a little bit like the United States. So I was appointed just over a year ago by the government of New South Wales, which is one of our 6 states. It's the largest state by economy and population. It's the largest, the New South Wales government is the largest employer in the Southern Hemisphere, and its public procurement is worth over $42 billion. So Esti was just saying that the Commonwealth government, the federal government, spends about $80 billion. If you take out defence spending from the federal government's budget, it actually spends less than the New South Wales government budget spends, because it's at the state level that a lot of things get built and a lot of the frontline services, health and things like that get delivered. So for almost 18 months now, in New South Wales, there has been a mandatory human rights due diligence law. Now, it's a bit cheeky of me to brand it that way, because it's not branded that way. It's called the Modern Slavery Act, and it's mandatory for over 430 public entities. So all government departments, all local councils, local Aboriginal land councils, and a whole range of other organisations established by public law, including some universities. Together, as I said, they procure over $27 billion US in a year. And I call it a human rights due diligence law, but as the name suggests, it's narrowly confined to modern slavery issues. But it is mandatory. So these organisations have formally legally binding obligations to take reasonable steps, is the standard, to ensure that they do not buy products of modern slavery, and then they must report on those steps. My independent role is to, amongst many other things, including supporting survivors of modern slavery, includes monitoring the reporting on those reasonable steps by these organisations, making recommendations to them on how they can strengthen their activities, also making recommendations to the public sector. I'm given a power to develop a code of practice around identifying and managing modern slavery risks in supply chains, which we're using, for example, now to develop a new code of practice for renewable energy value chains in collaboration with the peak green energy body, industry body here in Australia, the Clean Energy Council. In addition, I'm empowered to identify publicly those organisations that have these responsibilities and aren't meeting them. They go on a public register. And then, independent of me, we have a very powerful New South Wales Auditor General, and she has been given the world's first modern slavery audit power for public organisations. She hasn't yet exercised that power, but that's going to be a very important test when that moment comes, to check whether these organisations are in fact taking their reasonable steps. Now, you might say, well, reasonable steps, that still sounds like an implicit human rights due diligence obligation, not an explicit one. But the first day I took office, I had public organizations with these obligations lined up at my door, quite literally, asking for guidance on reasonable steps. So we've been working with them for over a year, and in about 3 weeks, we'll publish about 200 pages of explicit guidance on reasonable steps, which incorporate the UN Guiding Principles guidance and relevant OECD guidance and guidelines. It also includes a range of tools for these organizations to use to meet these expectations, which we anticipate have the force of law. Those tools include a new inherent risk identification tool so that they can understand the inherent modern slavery risk associated with specific product categories. And we have made very clear to them that we expect that electronics will be at the higher end of the inherent risk scale. That will mean that they have higher due diligence obligations than they would have if they're buying a lower risk product category. We're giving them new model contracting clauses based on the UN Guiding Principles that have been developed through a collaboration with the Responsible Contracting Project, which I believe has also worked with Electronics Watch in the past. And we're also providing model tender clauses so that they can incorporate these factors faithfully into their tendering and procurement processes. And the final thing I'd mention is a new reporting arrangement. So they have mandatory annual reporting arrangements, and additionally, they will be reporting at a transaction level on their high risk transactions. So that would cover, for example, all transactions over about $96,000, I should say, in the electronics category, for example. They will have to report certain data on that, which will then be made publicly available to create a longitudinal data set so that we can track how investments in change business practice in procurement inside government and the knock-on effects on suppliers are leading to different outcomes. Because last of all, I'm given a mandate to think about the effectiveness of these steps and to report back to that on Parliament. So a lot going on here, a lot of change happening in a short space of time, but very exciting for all of us. And we're looking forward to working with all of you as all of these actors go on this journey in the years ahead. Thanks, Olga.
Thank you very much. Absolutely, really impressive the amount of work that you're doing to define as well what are mandatory human rights due diligence obligations in the context of public procurement. I want to pick up on one specific point you've made, and which is this narrow scope of both the Modern Slavery Act at federal level at New South Wales. It happens the same in the UK. We're focused on modern slavery, but to some extent, and I think this, James, with the work that you're doing on guidance and engaging with public buyers, and ST, I'm sure as well, with the work you're doing at your level. We can see that modern slavery per se, while it may look limiting because it's very narrow set of and very severe set of violations, actually, if we understand it as the precursor, as obligations, as violations that actually enhanced by a context of human rights violations in general, that are perpetuated by the deprivation of freedom of association, of unfair labor recruitment practices, etc. We can understand, have the wider picture, and I think that is important. Are you seeing that in the work that you're doing as well, that you're to some extent limited or not by the narrow definition of what is the abuse?
So I'd say two things very briefly. Firstly, the offences that are relevant to my work are defined by the New South Wales law. They pick up the federal offences and also some state offences. In some ways, they're not that narrow. So, for example, all forced labour, deceptive recruiting, debt bondage would all be covered, as are a whole range of other online sexual exploitation, forced marriage and other offences. But already, frankly, just with those, forced labour, debt bondage and deceptive recruiting, there's a lot of relevant conduct that can be addressed in industrial and agricultural supply chains, for example. Secondly, the Act empowers me to promote prevention of modern slavery. And what I always like to say is, if something has become modern slavery, you've missed all the opportunities for prevention. it means that the harm has already been done. So playing on the front foot, taking a prevention approach means we have to deal with all of these adjacent violations of human rights, and indeed the vulnerabilities that underlie and drive those violations, as well as driving modern slavery.
The only thing I'd add there, Olga, to what James has said so eloquently, is that at the federal level, the Modern Slavery Act guidance is very much informed by the UN Guiding Principles on Business and Human Rights. And that's really the standard that's expected of reporting entities to demonstrate. And also, as a reporting entity ourselves, we also need to demonstrate that we have understood and identified the continuum of exploitation that occurs for modern slavery to take place. And that does actually pick up on the freedom of association issue that you mentioned, excessive work hours, and so many other indicators that we know are really good risk indicators to focus on. So to James's point, if you're only picking up modern slavery, then you really have missed a lot of the signals along that exploitation continuum. And our focus certainly has been at the University of Sydney, and even the way we write our contract clauses is to talk about risk indicators, is to talk about freedom of association, is to talk about freedom of movement, recruitment fees, deceptive recruitment practices. So it's not, as James has said in the New South Wales Act, it does seem narrow, but actually in practice, the expectation is that it does take a business and human rights approach that's more broad than modern slavery itself.
Wonderful. Thank you very much. And thank you so much to both for this conversation, and also to point in us as some of the wonderful guidance that are coming. So please do. I know they will be publicized, but please do make sure they reach us. And I'm going to now swiftly move us to our third conversation on the Norway Transparency Law. And I have as well two wonderful speakers. I have Crystal Tonstad, which is the Policy Director of the Norwegian National Contact Point for Responsible Business Conduct in Norway, and Kirsty Kofeld, which is the City of Oslo Agency for Improvement and Development as a sustainability advisor there. So we have Crystal and Kirsty. Yeah, I'm hoping I've improved the pronunciation of your name in these days. And the Norway Transparency Law, as always, was also received with a lot of enthusiasm at the beginning. And even if it just says as we talked before, with the names, the name of transparency rather than due diligence, and the differences between due diligence and disclosure, etc. But it really has been a law that was expected as well and welcome. So can you provide us a background to the law, and how is it working in practice, and what prompted the need for this law? And maybe Crystal, if you can start us off.
Thank you, Olga. Yeah, so as you mentioned, the title, or the short title of the Norwegian law, is a bit misleading. The Transparency Act. It is essentially also a due diligence law. Due diligence duty is at the core of the law, and the due diligence duty extends to human rights and decent work. So that's important to have in the sort of background. But of course, transparency requirements are also key, and I'll get back to that. But what prompted the law was, as we saw in many other countries after the Rana Plaza tragedy in 2013, was a number of campaigns in civil society, among politicians, that this is not acceptable. We can't have these kinds of violations in global supply chains, and we need duties on parent companies, on companies that are buying goods and services to prevent this. So in Norway, there were campaigns where consumers and civil society mobilized, and the focus then was on consumers' right to know, that consumers should have, and organizations should have a right to know on about the adverse impacts in conjunction with the production of good and provision of services, essentially working conditions in supply chains. A multi-stakeholder committee was established in 2018, which looked into whether such legislation was indeed necessary and expedient. And the resounding conclusion was, yes, we do need such legislation, but we cannot simply focus on the right to know. We cannot only focus on consumers and organizations' right to know. We need substantive duties at the core of this. And the consensus then in the committee was that one should build on existing international standards, most importantly, the UN Guiding Principles and the OECD guidelines for multinational enterprises. So the committee actually proposed a very broad scope for the law. The committee proposed that it should apply to all enterprises, as the Norwegian Environmental Information Act does, and it applies both to private sector companies and to the public sector. After the public hearing, which took place during the pandemic in 2021, the consensus then became that let's start with larger enterprises. So the proposal from the committee was adapted somewhat, and the duties that were proposed were then imposed only on larger enterprises. Still, the scope is very broad compared to similar legislation in other countries. It applies then to about 9,000 enterprises, and the threshold is actually quite low in comparison to other comparable legislation. And there will be an evaluation of this that has been announced in the preparatory works. The key duties in the law, the core of it, is the due diligence duty with respect to human rights and decent working conditions. And the OECD guidelines are in fact mentioned in the text of the law. And the due diligence duty then builds on the OECD guidance for due diligence, the 6 steps in the due diligence framework. And then we have the reporting requirement, which includes a duty to account for actual and potential adverse impacts on human rights and decent work, and how these impacts are addressed. And then there's this right to know. When you ask about what are their experiences so far, I mean, I think the support from the industry was generally very positive. Yes, good, we build on international standards, we build on the OECD guidelines. We need a level playing field, so due diligence should be required. But I think the difficulties or the questions have arisen to a great extent around this right to know. The right to know is essentially a right for any person, organization, to ask a company about information regarding how the enterprise addresses actual and potential adverse impacts on human rights and decent work. And I think this has been sort of a wake-up call for many. How do we respond to these information requests? How do we sort of balance out the efforts that we do in terms of due diligence and responding to the requests that do come? So this has been sort of a key element of the discussions in the first year of this legislation has been enforced in Norway. So I think, yeah, what prompted, you also asked what sort of prompted this. There was studies were showing that due diligence was not implemented adequately in Norwegian companies. The Norwegian National Contact Point was involved and did such a study and found that expectations from government is not enough. We do need requirements here. And also that we need to have potential for sanctions in the case of non-compliance. So yeah, I think in terms of the industry response also, it has been mostly supportive. There have also been questions regarding the scope of the due diligence obligation. How far does it go? And we have seen, I think, a key in the sort of formulation of the act was to avoid it becoming a tick box exercise. A key goal was to avoid a sort of routine reporting requirement. However, we are still seeing some of this. We are still seeing a focus on what do we need to report, what are the sort of minimum requirements. So what one does need a lot of guidance and a lot of discussions around focusing on the Due Diligence Act and what it calls for in itself. We've seen the due diligence duty includes a requirement to provide for or cooperate in remediation or compensation where this is required. That has not been very much high up on the discourse so far, and it will be interesting to see how this sort of develops after policies and procedures have come more and more in place. The tone from the top in many companies have changed, and then it will be very interesting to see how we move forward when it comes to this issue on remediation. And also, I think we have seen many changes in companies But then, of course, what we do need to get to in a sort of next step is what impact is this having on the ground, and research on this and efforts to really see, because part of the requirement is to monitor the impact of the work that is being done in companies. So we need to see how this is actually playing out in practice.
Thank you, Crystal. And Christy, maybe I'll come to you as well to see what impacts is it having, if any, on public buyers, but mostly how are public buyers trying to leverage the legislation to increase transparency and traceability? What are you seeing in your practice at the City of Oslo and in your work with other public buyers?
Thank you, Olga. Just first, let me just give you a little bit of a background on the human rights due diligence in the City of Oslo's procurements, because we've had a focus on human rights in our procurements, and we have had social criteria, including human rights, since 2013. And then in 2017, the so-called Oslo model was launched. And this is a framework for procurements in the City of Oslo, and it focuses on preventing labor crimes and social dumping and social criteria and procurement with high risk of human rights violations. So that included already requirements related to transparency and traceability. And this Oslo model has just recently been revised. It took quite long, but it was relaunched this year. And here the focus is on strengthening due diligence. So this has been included as contract clauses for procurements of both goods and services. And it builds on the UNGP and the OECD guidelines, and the model as such is aligned with the Transparency Act. But it should be noted that the Oslo model goes a few steps further than the Transparency Act. So thematically, it takes into account environment and corruption, and not only human rights due diligence. And it also has a wider scope than the Transparency Act. As Crystal said, there are some thresholds within the Transparency Act in terms of which companies are to conduct due diligence. But what we do in the Oslo model in the city's procurements is that it's not the size of the company that defines whether these contract clauses on due diligence are part of the contract. It depends on the nature of the procurement, the risk. So although it wasn't the Transparency Act in itself that led to revision of the Oslo model, it has been important to streamline and refer to the same international guidelines. So moving back to your question, how can we use the Act to increase transparency and traceability? Well, we certainly see that with the Act, more companies and suppliers that use the same language and terminology, and there's definitely a greater understanding about human rights due diligence as a concept, and it's a lot more than it was just a couple of years ago. And of course, this facilitates our dialogue with our suppliers. So it has certainly moved from a nice to do to a must do, as companies covered by the Act are obliged to conduct these human rights due diligence. We as a public buyer use the Act in the following manner, that for instance, if we're having this conversation with our suppliers and they're saying, oh, we find it really tricky, how do we work on these due diligence processes? We can actually bring in the Act and point to, well, if you're actually covered by the Act, you're anyway required to conduct those due diligence processes. So it's sort of the same thing, it's just more pushed for the same thing. And also that we see there's definitely the room for dialogue is different now that human rights due diligence is compulsory. And also, as Crystal said, that the fact that within the Act, the reporting is a requirement, and these companies are obliged to publish publicly the reports on how they do these due diligence processes. So of course, for us as a public buyer, it gives us additional information that we can look into when we're doing our contract management. But there's this one point that I would like to bring in and sort of as a caveat somehow, and that is that the original proposal for the Act had text that would have required companies to inform about their supply chains for specific products all the way up to the specific factories with exact locations. And this was taken out of the Act. And it means that even there is a duty to inform, companies are not obliged to give information on such a detailed level. So sometimes we've actually seen the opposite, that the Act is somehow used as an excuse not to provide information about traceability. So in particular from our suppliers, that since the Transparency Act does not require full transparency and traceabilities, these companies mean they are not obliged to provide such information to us. So it's important to note that we are referring to our own contract clauses where we explicitly state that we can ask for such information. So it's sort of greater room for maneuver through our own contract clauses than the Transparency Act. So it's just something to keep in mind there at the end.
Great. Yeah, that's a very interesting reflection. So unfortunately, we're running a bit tight on time. I would really like to ask you some more questions about how Oslo is actually seeing the progress in the relationship engagements between the buyers and suppliers, but maybe we'll leave it for, I'll come back to you because I want to make sure that we have time as well to discuss the German supply chain law. Thank you very much, Crystal and Christy. And now I'd like to bring in now Annelie Everman, who's the Procurement Sustainability Manager at ITDC Berlin, and Andres Siedenberg, who's an attorney at law and consultant in Germany, to discuss this other piece of legislative development that has also kept everyone very excited from the outside to tell us a little bit more about what's happening in Germany. And we know that public buyers do not fall directly under the scope of the law, but public enterprises do. So can you reflect on which of these entities and what are they using to comply with the law, the main challenges? So maybe Annelies, should we start with you or?
Sure, that's fine. Yes, thank you, Olga. Yeah, as you said, public buyers do not directly fall under the scope of the law, but there is a regulation that they have to exclude some of the companies who fall under the law and have been fined, but that's a very limited scope. And then we have some other companies, and that is like the ETDZ, which I work for. And as we are a public enterprise, we fall directly under this act. And so we have to do all of this due diligence measurements, and there's a much larger impact for us because of this. Well, there are so many questions right now. Perhaps I could just kind of give an impression of what public entities like ours who really fall under the scope do. And my impression is that there are different approaches, and it very much depends on the commitment of these public entities before the law. So you both have public entities who only write a code of conduct and ask suppliers to sign this, or they very much rely on consultants or on software, where there's a big market on since we had this law. And then there are others who try to do the due diligence work and to do their risk assessment, and also to have a monitoring of the contract clauses that they apply to. And so I think maybe a challenge of this law is that both ways are possible. And it should not be like that. So that is for me one of the main challenges right now. And perhaps just to give a short impression of what we do at the ETDZ, I think one of the major steps is that we became an Electronics Watch affiliate last year, because we are the central public buyer for electronic devices and IT services in Berlin. So this is our focus, and and I think that that is the best way to monitor whether we apply to the law. Furthermore, they hired me, so they have someone to implement this. And what we're doing right now, I have been doing last time, is do risk analysis and both on existing framework contracts to see what we can change with those, but also to have contract clauses in our new contracts, and to monitor those, and mostly with Electronics Watch then. Perhaps just as the first word. So
Right.
So
Andrea,
much.
please do come in and tell us about as well this context of public enterprises as opposed to public buyers, and how particularly for the industry, what has been the implications of the legislation.
Well, sure. Well, to clarify one thing, the supply chain law does not encompass every public company, but they have a limited for thresholds for employees. So right now it is only for larger companies with 3,000 employees, and upon next year it will be 1,000 employees, but still there are a lot of public companies which do not fall under this law and will not fall under the law. For the bigger ones, for example, hospitals, public transport companies, municipal energy companies, and organizations like that, they are caught a bit in a dilemma, because on one way they are obliged to comply with the Supply Chain Act. On the other hand, they are forced to select their suppliers in a fair, transparent, and competitive process in order to comply with the EU procurement law. So that is quite a challenge, since this EU procurement law only gives a few of tools which you can use in the process to select your suppliers, so that they comply with the law as well. As a quick solution, that's my view, a lot of companies have drawn up contract terms that must be guaranteed by all suppliers. So they sign it within the bidding process and say, okay, I will comply with the Supply Chain Act, but that is slapping a band-aid on a much bigger problem, basically. So right now we see a development towards a stronger focus on the supply chain, especially in selection criteria. So when the public buyers select who is allowed to submit a tender in a public procurement procedure, they select those companies which have some supply chain monitoring already included in their business processes. However, we still see that there is a lot of, I don't know, I'd say they are quite skeptical whether this will work, especially in the public sector, which is a conservative industry at all. So I still see a lot of public buyers who try to avoid this question at all, since it is also connected with a lot of more work, certainly, and they try to put it on someone else's back, like Annelie, for example. Now it's your task to manage this law, and what I see critical is that not a lot of public buyers take ownership with this law. They say, okay, it's somehow imposed on us and we'll comply with it, but they do not see the main sense behind that. That's what I see, but maybe Annelie can add on that a bit.
I agree.
It's an important point, the ownership, and I think it goes as well with what we were talking about in Norway about tick the box. To what extent is it something that you need to get out of the way, or you're actually really involved into, is not just something you have to do, but it's your responsibility and your obligation as well. So, Annalie, then what is ahead for you and your organization in terms of how you're going to address the relationship with suppliers to be able to implement some of these more stringent needs of due diligence?
Well, yeah, first of all, it is really just to say, I think this law was a start for the ETTZ to do social responsible public procurement. So it is really, we are at the beginning, different from perhaps Ghent or Oslo. So what we start is to have strict social criteria in our larger contract performance clauses. And most of all, of course, that we do monitor those, which is very time consuming, but is really just, yeah, the key of it all, because I see so many contracts where you have it in the contract, but after that, nothing happens anymore. And there's no monitoring, no communication. And that is really what we are starting now, that we are going to monitor it. And some of the suppliers are quite, yeah, didn't know that before. And now they, but now they are open to it when you explain it to them. And as I said, the other thing is to see at old framework contracts, because some of them are, yeah, going several years, and that's of course a bit difficult to change or to implement new social criteria, but that's what we're going to try as well. And I would like to highlight one other challenge that I see, because I think that's very important for the European directive as well. That is that in Germany, I see this, that a lot of federal state governments are considering now to, they did have some kind of progressive rules on public procurement and social criteria and public procurement, and normally the ILO core conventions. And I see several of them considering now to abolish these laws, because they say now we have this Lieferketten-Sorgfaltspflichtengesetz, so this act on supply chain due diligence, so we don't need that anymore. And it's really, it's a complete misunderstanding of the law. But it's really a backlash rather than a step forward. And well, I didn't see that coming before, but I really see this at in several discussions now. And so I think also for the European directive, it's really important to have a focus on public procurement and the role of public procurement and how to address this, so that we won't have the same situations there.
Thank you, Annalie. That's a super important point. And so in our last 10 minutes, I would like to invite the audience to please post some questions in the chat. We already have some. And I will, but before, so we'll collect a couple more. But so just to, in a way, bring all this together and wrap this up, and obviously to open the floor to the panelists if they want to add anything else. It seems clear from all the conversations we've had that you know, the public buyers not only have the capacity to move the market and to lead by example. It's not just a potential, but it is a responsibility, and it is a responsibility that has been developed at a level of a practice level of the public buyers, but also increasingly at regulatory level. And I think, Annalie, to pick up on your last point, there is a risk that by advancing with certain legal frameworks, the need to compromise, for example, at the EU level, obviously it may, and it's alarming, and thank you for putting this, lead to a race to the bottom in terms of, you know, having to find a common ground and hopefully the new legislatory developments will not constrain those who are actually doing more and who are much more progressive, and this includes the affiliates of Electronics Watch. I think another important point that we've heard is the need for guidance, and that is not just, you know, public buyers are asking for it, companies are asking for it, and as the practice that James has highlighted as well, you know, a leadership on guidance and implementation is key, and the states need to invest in this, as Robert said as well, is states' obligation. Another point I want to highlight as well is that, and also it was mentioned in one of the panels, that this is, I think Crystal, was you, need to measure what's the impact on the ground. We have the practices now, what is happening and how is this changing, coming to the ultimate result, which is changing the working conditions of workers and providing remediation. What happens? We're focusing a lot in preventing, identifying the risks and preventing them. Well, we need to move on into focusing on remediation of harm, and how, and it's even more complex, how are public buyers going to be involved in the remediation of harms that have occurred to some extent related to the purchasing decisions. So I think this is some of the points I have picked up. If any of the speakers want to add any more, please be welcome. And I'm going to, I think, James, you have your hand up, please.
Yeah, Olga, I think those are all exactly right, on the money. And I think what we also need to be thinking about is what I would call purposive collaboration. You know, in the private sector, there's a lot of attention to the idea of pre-competitive collaboration. How can we empower the private sector to work together to find economies of scale and to ensure consistency in the way they approach suppliers, for example? I think we're seeing a level of sophistication emerge across different jurisdictions now that are all driving in the same direction around public procurement, that puts the onus on us to think about how we can ensure that consistency in the way that we all as public buyers are approaching risk analysis, even down to the supplier level. That's not easy to share risk analysis of suppliers across borders without violating various, for example, trade rules or other rules like that, but also risk management expectations. Suppliers don't want to see different risk management expectations from different buyers, whether private or public. They want consistency. Now, that isn't simply a question of harmonization. It's actually about interoperability and consistency in the underlying philosophy. And I think what we hear here tonight is that there are really important innovations and experiments going on that need to be mutually supportive and reinforcing, and that doesn't happen by accident. So I guess this is an invitation to everybody involved in working with public buyers, whether you are a public buyer on the panel or whether you're involved in the Electronics Watch ecosystem, if I can call it that, to think really deliberately about how we can work together to share information, approaches, and support each other to ensure this pretty fragile experiment doesn't collapse under, you know, pushback that will inevitably come as the transaction costs of change, which these laws are about change. They're about changing business processes so that they don't create risks to people. We have to prepare. There is going to be a pushback, like was just described by Annalie at the state level, them divesting themselves of the responsibility, saying, okay, business can handle it. We need to prepare for that pushback, and we need to work together to make sure there's real consistency in the way that we are asking public buyers and suppliers to respond. So open invitation. Feel free to reach out to us at any point, and we'd love to have that conversation with you.
Wonderful. Thank you very much, James. We have a couple of questions that we can pose in the last couple of minutes, but if anyone else in the panel wants to say a final word? Great. Well, then I will use my chair prerogative to invite the question of one of my colleagues at the Business and Human Rights Research Center, Anya Clark. Thank you all for the great discussion. And this question is for Anna Lee. It was great that you've incorporated the model contract clause in your contracting. Can you say a little more about which clauses you have incorporated and whether these contracts are or could be made public? Anya leads the Know the Chain benchmark at the Business and Human Rights Research Center, and one of the metrics is the model contract clauses.
Yeah, sure. Our goal is to use the electronic swatch contract clauses. That is for ICT. We haven't done that yet because I just started for some months ago. And right now we use, it's called a Declaration or Verpflichtungserklärung, Beschaffungsamt and Bitkom. I can send you a link to that. It does have some limitations, I think not from the scope, but from the monitoring. But what we are doing is that there is a sentence in that you can do some monitoring with third parties, and that's where we clarify that we do this monitoring with electronic swatch. And I think that's the crucial part about this. I can send a link to you.
Wonderful. And then there's a question about the UK new Parliament, a new Public Procurement Act. I know, Robert, you asked the UK representatives in this panel, you and I probably should be able to answer this, but we probably can't. But I'm not, well, sorry, not preempting your capacity, but does the panel consider that the new Procurement Act 2023 in the UK as a great opportunity to establish better practice in responsible power procurement? And if so, what do public buyers need to ensure to ensure its successful implementation? You have any insights?
I'm sorry, I'm not in a position to answer that because as a working group member, I think that would be not appropriate for me to answer.
Yes, you're absolutely right. Apologies, I didn't. I addressed your question as a professor in the UK, but apologies. But I've got Christy wanting to come in as well, so.
Yeah, I could just mention, I didn't mention previously that in the Norwegian national law, there is a law on public procurement, or sort of an act, which might be interesting in this case, which states that there is a requirement that public buyers need to have suitable routines to promote respect for basic human rights in public procurement, where there's a risk for violation of such rights. So, for instance, the City of Oslo, what we've done then is we're having these social criteria and having this risk assessment of the different procurements we do, and really the framing of routines as these due diligence requirements. So just sort of an experience from our end there.
Yeah, that's great. It is important, I think, to be able to coordinate due diligence laws and public procurement laws. These two legal systems are not adequately coordinated, and we have an opportunity when we start the process of reforming the EU public procurement law, which is an absolute Pandora's box, obviously, and we will hopefully be able to push for this. So, Crystal, in the last 30 seconds, please come in.
Just echo what Kjersti just said, that it's really important, the synergies between the Transparency Act and the Public Procurement Act, and that the contract performance clauses now are based on the OECD due diligence guidance. So that's really important. This update was done to align it with the Transparency Act. I think it's also being revised now, but at least those synergies are already there. And just with my NCP Norwegian National Contact Point hat on, I would just always promote the OECD due diligence guidance for RBC as a really good starting point and a way of sort of collecting all the forces in a good direction. Thanks.
Wonderful. Thank you very much. And to be very British about it, so people know that I'm Spanish, so I'm always late, but with my British hat. I am going to close this panel right at 12 CET. And it's been an absolute pleasure and delight to moderate this panel. Thank you very much to all the participants. And we have to continue the conversation. We've pointed out what are the opportunities in the legislative frameworks that are being developed, and what are the gaps, and what are the synergies that we need to continue to have in the regulatory frameworks, in the practice frameworks, and in the engagement with all the relevant actors. So thank you very much, and thank you to Electronics Watch for bringing us together, and have a fantastic day or night.
Thanks.
Thank you.